Okay. Whenever you're ready, counsel.
Thank you, Judge. Thank you for your sacrifice and it's not without some recognition of the sacrifice you make. I understand that I think what I said in the beginning about the experience of being a juror is one that resonates. It's one that when you get through the process, you realize, wow, I really performed a vital function. And during the course of the trial, you get some insight as to it's important to both sides. Okay, and it should be. I mean, that's how the crucible of the truth, that's how we apply it. And so I want to start off with expressing gratitude for your sacrifice. Now, when we started off, we talked about voir dire, the instructions that you're going to see. And to me, the instructions that the court will give you after my rebuttal this morning, they guide you, or if you will, if you think of it, it's a playbook. If you talk about voir dire a little bit, when you come here as a juror, and you're like, well, gosh, how am I going to decide this? What am I, I've never done this before. It's a new experience. And the best place to start, I think, is the instructions. We talked about it over here. The instructions, essentially become your playbook. They'll guide you in deliberations, the process of how to decide a case, judging the witness credibility, understanding what the charges are. Okay, and if you think about the first instructions you're going to receive is presumption of innocence remains with the defendants today, because if you talk about voir dire, you wouldn't want to make a decision, an important decision in your life, until you have all the facts and the instructions from the court. I mean, it's something you wouldn't do. Now, we also talked about in voir dire during the process of a trial, how that presumption can be removed. I mean, it's not an insurmountable hurdle. It's something that happens quite frequently every day in the United States during jury trials. Okay, the burden of proof rests with the prosecution, and we accept that burden. And you point your finger at somebody and make an accusation, you should be willing to support it with evidence. And the next question that comes to mind is, what is the burden of proof applied to? We talked about in voir dire a little bit in opening, if the burden of proof applied to every fact and circumstance that was testified to during the course of this trial, that would be an insurmountable. Never be able to achieve satisfaction of every fact that was testified to has to be proven beyond a reasonable doubt. So then the question becomes, well, what does the burden apply to? Well, it applies to the allegations. It applies to what's charged. Okay? And there's 3 crimes charged in this case. And as I said early on and during opening, this case is a simple case. I mean, at the end of the day, the charges are providing material support for terrorist attack, being a member of a gang, and having a gun while committing the first offense. Okay, so the elements or the definitions of these crimes, we talked about them with you in opening, talk about them with you in closing now. I told you these instructions are not mysteries. I mean, the 3 books that sit behind Judge Wilson in the red are the jury instructions in the state of Michigan. We have all of them. It's got it's a known quantity is what I'm trying to say. So those are very good guide posts for you to use in deliberations. The burden of proof is proof beyond a reasonable doubt. And as you all promised during voir dire, you wouldn't let anybody whittle that away because that would be unfair to the defendants. And you wouldn't let anybody inflate it or add elements to the charges, okay? Because that would be unfair to the people of the state of Michigan. So both sides deserve a fair trial. And as we talked about before, dear, call it the way you see it, but give each side a fair trial. Evidence. I mean, how do you decide a case? And the judge is going to instruct you that you decide it based upon the evidence or the lack thereof. And evidence comes from principally two places: that witness stand and any exhibits that are admitted during the witness stand and any exhibits that are admitted during the course of the trial. Okay. So with that in mind, one of the things you're going to be asked to do is think about witness credibility. Okay, we're going to talk about that here as we go along. And judging witnesses' credibility, you're going to get an instruction on, and it's age and maturity of the witness. Was the witness able to see and hear things clearly that they're testifying about? Does the witness have any special interest to lie or tell the truth? Okay, and finally, does the witness's testimony agree with other evidence in the case? Because if it does, this is called corroboration, and that witness's testimony becomes more believable the more it's corroborated by other evidence in the case. What isn't evidence is what I say, what Mr. Johnson says, what Mr. Ballard says, and what Mr. Patrick says, and also what Mr. Adamant says. I mean, we are the lawyers in the case, and we are striving to deliver to you a concise, understandable body of evidence that demonstrates the three charges. Nothing more, nothing less. Okay, so that's some other things that you might think about are motive. The judge will instruct you. Did the defendants have a reason to commit the crimes charged? Because if they do, that's motive is not an element. It doesn't have to be proven, but that's evidence that you can consider in your deliberations. We talked about in voir dire the idea that you can't unrob a bank. That once the crime is committed, what you do afterwards might be important if you're at a sentencing, but once you commit a crime, you can't undo it. Okay, and that's important in this case to the extent that when you see the timeline of events, you can begin to see when certain things happen, and what happens after that might be important when you think about a defendant's intent. Okay, and there's some evidence in this case that we rely on for that. It shows you what Mr. Bellard, what Mr. Musico, what Mr. Morrison were thinking about. And Ms. Dadamani yesterday was correct. The purpose of the statute that the defendants are charged with, providing material support for terrorist attack, it doesn't come out of thin air. When you think about how we as a community and as a state govern ourselves is, we elect individuals to go to Lansing. We each have a senator, we each have a House member, then we have a governor. And if those three groups, the House, the Senate, and the executive, the governor, believe that a law should be passed, and it's an arduous process, then it is. The House passes it, the Senate passes it, the governor signs it, and it becomes law. And what Mr. Dadamani's reflections yesterday kind of pointed out is, the reality of life in terroristic acts after they occur. The facts drip out slowly, and you begin to see, wow, there were things that happened that people knew about, and you begin to see how these events that happened. And an example here in the state of Michigan was the Oxford school shooting last year. And as after that's happened, the facts come out, and we begin to see that this didn't happen in a vacuum. It occurred, and people knew certain things along the way. Okay. The FBI was very well justified in investigating the Woolworth Watch. Okay. And in fact, what their, primary mission was, if you remember the testimony of Special Agent Impola, was to disrupt or not allow such an event to happen. Okay, I mean, that is the goal, is to not let the event happen. When you look at the investigation, its genesis and how it began and what it collected along the way, it very good that the FBI, because when you see that how close Adam Fox got to the governor, you can see how a very bad event was thwarted. Now, they're not charged with trying to get at the governor. They're not charged with pointing rifles at, and pulling the trigger on police officers. I mean, what they're charged with is providing material support to someone who was trying to commit a terrorist act while being in a gang and possessing firearms while they did so. I mean, so that's the framework, that's the allegation, and I think that's the best thing to focus on. What evidence supports that? Corey, can I have the lights down just a little bit?
Sir.
Thank you. In my remarks that follow, I'm going to stick with the presentation that was delivered yesterday in the order in which it was. And Mr. Johnson began Mr. Musico's position. And, you think about the three charges again: providing material support, being in a gang while you did so, and having a gun while you did so. The question becomes, well, what did Mr. Musico provide? And what was it that he provided to Adam Fox? And, much has been made about who invited Adam Fox to the June 28th training. And you can see here, this message from Mr. Musico to Mr. Fox makes clear that he invited him to come out there. It wasn't Dan. Dan didn't cause Adam Fox to come to this group. And it makes clear also, what the goal of the group is. And the reason I say that is, during the course of the trial, you learned a lot about what Adam Fox was about, and you learned what Barry Croft was about. And as Ms. Donovan so eloquently put it yesterday, their brand was very identified. I mean, their brand was violence, and their brand was dangerousness. Now, it's not illegal to be dangerous, okay? But it is insightful when you think about that, when you judge a person's intent against the crimes charged, okay? Did they intend to help Adam Fox? And the statement by Mr. Musico that the roundup after training, couldn't be any clearer. If you're not down for violence, you need to leave. Mr. Musico was a founding member of the Wolverine Watchman. And I think a logical way to look at what Mr. Musico, and I'll talk about Mr. Morrison here in a moment, but for their contribution of allowing their property to be used at a training site, Adam Fox doesn't get the benefit or as far down the road towards his plan for political violence as he would have, but for Mr. Musico and Mr. Morrison providing a little piece of property for this training. Okay, this is not in this location. The importance of it really can't be overstated. I mean, it is a place where they can go to, it's secure, it's controlled by, individuals that trust. And it provides the opportunity, and really, I mean, not only the opportunity, but it provides the means, if you will, methods, or the ability to train in a way that makes them far more dangerous for two reasons. One, because the team component, okay? Whenever you have a team in a violent situation that's trained together and understands each individual's responsibilities, that's a more formidable enemy. That's a more formidable force than a single individual. And what this property gave Adam Fox was the ability or location to go train. It was suggested to you that Mr. Musico was a house guest yesterday. And what you see here is a picture of his bedroom after a search warrant was executed there, and after the defendants were arrested. And, think about does this look like a place where a house guest is staying? And no is the answer. I mean, the testimony and the evidence was quite clear that Mr. Musico was dying. Okay, that was his residence. That's where he stayed. And to suggest that he was a house guest without any authority would be incorrect. And logically, I would point to the last slide, which is he is there at the property and he's telling people in the roundup at the end of the training, if you're not down for violence, leave. And he's telling people, if you're not down with our program, get off our property. The person who can expel somebody like that is also a person who can invite. Okay, when you think about that logically, the ability to kick somebody out means you also got the ability to invite them in. Okay, and think about Joe's position, Pete Musico's position in that household. Okay, at the time, he's 42. Mr. Morrison is 26. And right there, there's an age variance between those two individuals, and the age variance benefits Mr. Musico when it comes to his authority, just in terms of his stature in that little community inside of that house. Think about his position with the other resident there, Jada, that is Joe Morrison's wife. That is his daughter. Okay? He has a position there by being father, almost like a patriarch, and he's the patriarch of that household. Joe, being the son-in-law, is he is of less stature than Pete, just because of the fact of the relationship of the parties. He's married, the son-in-law is typically deferential to the father. So you combine the age, the relationship of Joe and Jada, the marital relationship of Joe and Pete. Pete is the patriarch. He has much more authority than house guest. Okay, remember what he said. If you're not down for the violence, leave. The person who can tell someone to leave also invite you. So he's not a house guest. One of the things that the gang charge captures, and again, when you go back, like, why do we have this law? Why do we have this law in Michigan? It's being a member of a gang while you commit another felony, a separate offense. It's for the reasons that I spoke about 2 minutes ago. The body, the group, is a more formidable opponent. It is a more dangerous body than an individual acting by him or herself. Okay, so there's a reason for that law. We don't want criminal gangs to exist. It's not like a big stretch, but you got to kind of think about the policy behind these statutes and what they're charged with. So when you think about the gang component, During Mr. Johnson's closing yesterday, in his remarks, he, admitted that the Wolverine Watchmen had rules and processes. And they did. I mean, they had the vetting, and, that was a very important part. They had they used wire so they could communicate, securely. They purged members, okay? They had a membership criteria, no police, no FUDs, no bootleggers. And, these are the processes, this is the embodiment, if you will, of a gang or a group. And again, when you think about the policies, like, gosh, why don't we want that in our community? Because gangs are more dangerous than single people. For sure. Okay. The jury instruction you'll receive, a group of persons was a gang, and a gang is 5 or more people with a continuing relationship with each other. Yesterday, there was some argument, I think by all 3 counsel for the defendants, that instead of continuing, the word continuous was used. It's a little different, but I would suggest to you that's an attempt, continuous communication. I don't know anybody on the planet that has continuous communication with any other individual. And by kind of inserting that word continuous versus continuing, it's essentially trying to raise that burden of proof a little bit. It's like, no, we didn't talk continuously. Well, nobody does. It is a continuing relationship. And the central time, or the time, that should be focused upon is the date of the crime. Date of the crime, was there a continuing relationship with at least 5 people in the Wolverine Watch? And the answer is yes. Now, again, part of their processes and their structure included leadership. I mean, there was a organization to the Wolverine Watchmen that actually was quite substantial. They, their training itineraries were organized. And doesn't that make them more effective when trained? You think about it, and you heard you saw some exhibits during the course of the trial that pointed out, what the training itinerary was going to be for certain dates. And that makes them, again, more organized. Their training is going to yield a higher benefit. They're going to be a more formidable force after that kind of organized training. And, a leadership structure adds to the formidable nature of the group, because now, there is a communication line, there is a structure for decision making, there is a structure for, open discussion within the group, if you will. So these are all things that lead to, finding that the Wolverine Watchmen were a gang. And they had the common name or symbol. There's the exhibit on the easel over there is a group of the Wolverine Watchmen, far more than 5 people. Leadership or command structure, and then membership criteria. And you remember the membership criteria that was put out by Joe Morrison in one of his first posts on Facebook. You didn't want any status, didn't want any bootlickers, didn't want any FUDs, people that hunters that think they're proficient with their guns, but they're not tactically battlefield ready. No cops, no feds. So what's the main thrust of Mr. Musico's defense? And really, it's a common claim shared by all the defendants in this case. And it's what we'll call the wheel of conspiracy. Okay. And the conspiracy essentially that's put forward by the attorneys for the defendants on behalf of their clients is that anybody who came to that witness stand and testified against them were lying. I mean, it's one of the main thrusts of their defense, is that you can't judge or you can't trust the witness's credibility when you determine whether or not the elements have been proven beyond a reasonable doubt. So, you look at the wheel of conspiracy here, their argument requires that, you find that each one of these defendants lied. It's been argued that each one of these witnesses, rather, lied when they testified. And, that begs the question, well, why would all these individuals who are not associated, okay, I mean, like Mr. Toast from the Mug and Bop store, he doesn't know, Sergeant Orvis, he doesn't know Dan. Trooper Ramey, she doesn't know Mr. Ramirez from the Mount Morris Township Police Department. Lieutenant Green, he's never met Dan before. Okay. And what the thrust of their argument on behalf of the clients is that, they all lie. And you shouldn't trust them when you decide whether the elements have been proven beyond a reasonable doubt. And the thing that I ask that you consider is, well, how would these individuals, 9 individuals who are not connected in any way, get together and in unison all lie against the 3 defendants who they don't know? I mean, Dan knows them because of his work as the FBI. And by the way, I mean, to suggest that Dan committed the crime while he was working in the capacity of an undercover informant for the FBI does not wash. I mean, people that are engaged in that are, they're not they're not committing a crime. Okay. So I'd ask that you think about, when you think about these 3, or these 9 witnesses, rather, do they know each other? Do they, is there a reason that they would all lie in unison against the defendants? What would be their motive, all of them, to lie about what these defendants did? And the short version is anybody that got on that witness stand and testified against these defendants was going to get the allegation lodged against them by the attorneys for the defendants that they're lying. Okay. And as I said earlier, what we provide to you is not evidence. The allegation that, Ramirez lied about Officer Ramirez, he's the gentleman from Mount Morris Township, who knows Dan, gets the phone call or the text from Dan. He goes over to Dan's house and sees what he sees on Dan's phone on wire. And it's the Wolverine Watchman talking about getting addresses to police officers' homes. This is at the earliest stage of the investigation. This is March of 2020. And that's a common theme through this case. The finding the addresses to individuals' homes that the defendants felt aggrieved by was a common theme through the entire course of this case. It takes a little detour when Adam Fox comes in, because Adam Fox starts off with the idea, let's storm the Capitol, take hostages, televise, a trial, and, we'll have it out there. Okay. Mr. Fox eventually comes to the idea of, no, better to go to the houses. It will be less confrontation for us. It will be easier for us to achieve our mission. And we won't be a Leroy Jenkins running into the Capitol, dying for nothing. Okay? So Adam Fox gets a great benefit from being the Wolverine Watchman. It's not just the medical training he got, although that's something that was important to him. his plan became much more refined when you think about how it went from let's storm the Capitol to I'm at the end of the governor's driveway, their house up there. Okay, that's a better plan for Adam Fox than storming the Capitol, 20 or 30 guys. So I come back to, you know, the common claim is that they all lied. So there's Officer Ramirez at Dan's house, and he came in here and testified for you. And, you know, this is a township police officer who has served over a quarter of a century in Genesee County. Okay, he is who he is. But that guy, when he came in here and told you what he saw on Dan's phone, I would suggest to you that his testimony was highly credible. He is not lying about what he saw in there. He said, I saw they were looking for police officers' home addresses. And that concerned me. Step back from that one statement. He's a police officer. He's living in that jurisdiction. He's looking at that going, huh, you know, that is troubling, at least to him, and, you know, personally. And he tells you what he did. He says, no, you didn't take pictures of it. I mean, you know, he's a road patrol officer for a small township in Genesee County. Okay. But that doesn't make his testimony any less believable. Okay. And he says what he saw on Dan's phone. So think about the wheel of conspiracy, and, you know, really what it boils down to is, well, Ramirez didn't take a picture of it, so you can't believe it. Okay. Well, let's kind of walk that down the road a little bit. If Ramirez had taken a picture, do you think it would have been accepted? And the answer is no. I mean, the next challenge would have been, well, we don't know when the picture was taken. We don't know if that picture was Dan's phone. I mean, there's always an attack. And really kind of what the question is, you know, when would counsel for the defendants be satisfied? In behalf of Mr. Musico yesterday, Mr. Johnson suggested there's nothing in the chats about names and addresses. What we have here is really one of the early introductions to Pete Musico's 3-plan. And just to recap, 3-plan by Mr. Musico was actually a better plan than the Adam Fox plan. Because the 3-plan was go to their homes at 3 a.m. and do what you got to do. Okay. And the 3 a.m. plan is much better for an aggressive force like the Wolverine Watchman than trying to storm a public building like our Capitol and take it by force. Okay? You don't need as many people. And that's one of the things that the Wolverine Watchmen were very interested in doing, was recruiting. They wanted as many people as possible. You know, like they wanted, you know, well-disciplined gunfighters was the word that was used. So this is a post by Mr. Musico in March, and, you know, going to the homes of law enforcement and people who are elected and serve the public that way, to cause fear and intimidation was part of Pete Musico's plan. Again, nothing in the chats about names and addresses. And the chat that we're seeing here is again from May now. And, you know, he has this word here, protesting in front of their houses. And there is a little bit of decoding that really has to go on when you look at how Pete Musico and Joe Morrison and Paul Bellar communicated. And you know from the course of this trial that Pete Musico is not interested in protesting. He's not interested, as I think Mr. Johnson said, about going to the Capitol and stomping his feet for a cause. Okay, that's not what he's interested in. What he's interested in is the opportunity confront law enforcement and to attempt to instigate them into a violent confrontation. That is something he does want to do. He's not out there carrying signs and marching the march. I mean, to suggest that these three defendants were interested in that kind of social change is not supported by any of the evidence during the course of this trial. He sees, even in this setting, the terroristic value in going to a person's home, even if you accept the word protest or protesting that he has there. As I talked about a little earlier, part of the accusation, or rather the argument as to why Mr. Musico isn't guilty of the crimes charged is that, well, Dan led the training, Dan committed the crime. No, that's not the case when an informant works with the law enforcement in the state of Michigan to investigate crime. No, they are not committing a crime when they do so. And when you think about it, Dan had to play a role. And the role that he had to play, and he summarized it pretty well when he testified. He said, I gave the FBI a unique opportunity to see what was going on in this group. And in doing so, when you think about what he did and the number of times that he put himself in harm's way during the 7 months that he was involved in the investigation, remember, at the end of the investigation, he had to sell his house. I mean, it sounds simple, but just think about I did this thing for, the FBI and the state of Michigan. I helped them discover a group of men that were, targeting the governor, and a group of men who were helping and training the person who was targeting our governor. And the thanks I got for it was I had to sell my house at a loss, and I had to move. I got a family. I had to get a different vehicle because the threat that these guys pose. Okay. So, the idea that, he was going to go there and sit like a bump on a log, so to speak, and not do anything and just observe and report, it's not possible. He wouldn't have been allowed to stay. They would have seen through him very quickly. Okay. So in order to stay and have access to the group, he's got a role to play. And he's got to follow the lead of the Wolverine Watchman. And he did. And he did what they asked him to do. They asked him to help train. Okay, I'm going to run some training for you. And you heard what he said. Basically, a lot of my training was acting as the safety officer. A range safety officer is somebody who is responsible for the safety of the range during the time that it's in use of a gun range. We're training. And, that is his role in order for him to provide the access to, remember, it's not just the FBI in the state of Michigan. His access also gave you the insight into what was going on in the Wolverine Watchman. Okay. And that, I'll leave you with this thought about Dan committing crime. Think about who brought Fox into the group. There's Joe Morrison. Okay. Dan did not bring Adam Fox into the Wolverine Watchman. It was first Joe Morrison and through his communications with Barry Croft. Okay. And Croft said, I'm sending, some Michigan, Croft said to Fox, I'm sending some Michigan guys to you. Okay. And so Dan didn't bring Fox into the equation. It suggests that Dan, is the person that actually committed the crime, is disingenuous. Okay, providing material support for an act of terrorism. Let's talk about the elements a little bit in this one. I talked about it earlier, but for that training, but for the Dunn Road property where Joe Morrison owned and Pete Musico reside, they don't have a place to train. Okay, so the facilities are really important. They don't have a place to do what they want to do, but for Joe Morrison and Pete Musico. Did the defendants know that Fox and Croft would use that, or would use that training, at least in part. It doesn't have to be exclusive, and it doesn't have to be, the single thing that allowed Adam Fox to do what he did, which was target the governor, carry out and facilitate or avoid apprehension. Think about Paul Bellar's acts after the 7th of July, the Ghost Group meeting, after he starts his own group, okay, for an act of terrorism. And there again are the definitions of an act of terrorism: violent felony, which is dangerous to human life, and intended to intimidate or coerce the civilian population or influence or affect the community government. If Adam Fox was successful in what he had intended for our governor, and I don't care who you voted for, but to target our governor would be an incredibly destabilizing event in our state. What they had planned would have rocked this nation. I mean, it would have been on the front page of every paper. It would probably been international news. The state governor was targeted for violence. Okay, so don't underestimate the dangerousness of the defendants and the man they were helping. Okay, remember, the charge isn't that they committed the terrorist act and went after the government. No, the charge is that they provided material support to the person that did. You heard from First Lieutenant McManus from Michigan State Police, and he came in here and testified for you that he's the current post commander of Lake Post. Before that, he served 2 governors in the executive protection detail, and it goes back decades, Governor Miller. And you could tell he takes his business very seriously. And a couple of points that he offered. Number one, anybody who gets into that detail, and they're all young state troopers. Some of them was like, none of them were 50 or 60 years old. And it makes them very clear that you may very well have to give your life in protection of our government. And the other thing he pointed out was the serious nature of that mission, and how this event changed what they did. It changed how they protected our governor. It changed the means and methods that they used to do so. And what the Wolverine Watchman did in helping Adam Fox did have an effect on you and government. And it was intended, if it happened, to have a very destabilizing effect on the civilian population, the statute calls it, or people of the state of Michigan, is maybe another way to state it. Part of Mr. Johnson's closing on behalf of Mr. Musico was, well, Mr. Musico wasn't in the leadership chat. And this argument is essentially framed in a way to suggest that Mr. Musico had ancillary or secondary or less than important positions within the Wolverine Watchman. And that's not the case. I mean, he doesn't need to be in the leadership chat. The reason he doesn't is because of the evidence that was submitted during the course of the trial about how in lockstep Joe and Pete were. And if you think about kind of the familial relationship aspects of their relationship that I talked about earlier, and you can begin to see that these two are very close to each other. I mean, they spend every day together. They run a chimney sweep business together. They live together. Joe is married to Pete's daughter and has a grandchild, now, and on and on and on. So, no, Pete doesn't need to be in leadership. In fact, there was testimony and evidence submitted during the course of the trial that, Pete knew everything that was going on through Joe. And we'll talk about that in a moment. But his own words, Mr. Musico's own words, when he's talking to Dan and the exhibit that we admitted, that he talks about, 60 to 70% of the ideas that came to fruition within the Wolverine Watchman, he had a hand in. And the reason he did is because of where he lives and because of his relationship with Joe, and also because of his intent. And this is not something he did unknowingly. Remember what he said? He says, no, I'll tell you, buddy, that's your generation. You go get it. And he fed Joe what he needed to know. He talked very quickly about his hand and how he helped the Wolverine Watchman, and he did have a quasi leadership position. Think about, when you think about whether or not Joe and Pete are in lockstep with each other, this is when each of them connected with Barry Croft. And it's an example of how Pete and Joe are tied together. On May 10th, Mr. Morrison friends Barry Croft, and 15 days later, Pete Musico does the same thing. Okay, so maybe you're thinking at this point, possibly a coincidence. Well, here we have their communication, or their connection rather, with Adam Fox. And this is another example that shows how tied together Mr. Musico and Mr. Morrison are. On the 8th of June, there's the first direct message and voicemail message from between Mr. Morrison and Mr. Fox. Within 24 hours, Musico is friending Adam Fox the next day. And the question then becomes, one of the things we talked about, ladies and gentlemen, for year and opening, was circumstantial evidence. And circumstantial evidence is, direct evidence is, I saw the man come out of the bank. He's the guy who robbed it. He's sitting over there. It's direct evidence. Witness saw directly. Circumstantial evidence is evidence that leads to a reasonable conclusion based on facts. And, for instance, I use the example of a person comes in from the outside here, wearing an overcoat, kind of umbrella, he's got small droplets of water on his jacket. I think, it's raining outside, would be a very reasonable conclusion based on those circumstantial evidence. This circumstantial evidence of when they're connecting with Croft and Fox isn't a mistake. It's not a coincidence. Here's another example on the double date that Mr. Morrison goes on with Jada and Mr. Fox and his girlfriend. This is a message from Mr. Musico to Mr. Fox on the 27th of June. And and he's telling Adam Fox, hey, by the way, the woman you're with tonight is my daughter. Okay? He's sending a message there. And Adam Fox responds back, yeah, we know, we just got done. I mean, there's a reason that Pete Musico knows about this double date, is because him and Joe are tied. Okay? So there's three good examples of things that are not coincidences in and how closely connected Joe Morrison and Pete Musico are. Think about the flow of information, if you will, in different settings during the course of the trial. And here is one you might want to think about. This is the flow of information regarding Paul Bellar's warning that Dan was a mole. Okay, and now remember, and I'm trying not to blend the defendants' closings. I'm going to try to keep them compartmentalized for ease of understanding. A lot was made about by Mr. Patrick on behalf of his client, Paul Bellar. And he made a lot about, Paul was gone, Paul left the group, Paul left the state. Paul, essentially what his argument is what we call withdrawal. Okay? he has withdrawn from this criminal activity. And you're going to see that he did as I move through my presentation here. But it's worth noting at that point when we look at the flow of information and how it moves through the group. On the 18th of August, Bellar sends the message that's above there. And the reason it says 19 is because of the UTC time. It's actually, if you do the hours for UTC time, it's actually on the 18th. And that gets from Bellar to Morrison on that date. On the next date, 2 days later, Musico is moving the same information to Adam Fox. Now, remember, Paul communicated directly with Joe. And now Pete is moving the same information to Fox. So the circumstantial evidence there clearly suggests that Joe told Pete about Paul's belief that Dan was the mole. And here is Mr. Musico's voice message to Adam Fox about that possibility. Adam, that's okay. You've heard the audio before. This is a transcript. Yeah, I'm working on nailing down a couple of infiltrators right now. And, you know, I talked earlier about Dan and putting himself in harm's way. And, you know, when you see what was going on here in August and what Mr. Bellar was providing back to the Wolverine Watchman, he had not left his loyalty to the Wolverine Watchman. And Dan is lucky to be alive today. We're back to the great conspiracy wheel. And, you know, here's another example is, you know, the testimony of Trooper Rachel Ramey was attacked by all counsel for their clients. And, you know, she testified about her interaction with Pete Musico at the Capitol when he said to her, you know, I don't care if you're a fucking Marine, I'll kill you. And, you know, much was made of, well, did you have body video or body cam, you know, going, you know, was there anybody else around? Who else could have testified about it? That's increasing the burden of proof. They're trying to increase the burden of proof. Rachel Ramey came in here, you know, United States Marine Reservist, a Michigan State Trooper, serves our state, our country honorably. And she says, look, this is what happened out on the Capitol grounds. And because she pointed the finger at one of the defendants, she got accused of lying. You know, she's not worthy of your belief, was the argument that was put forward really by all three defendants. Okay. And no, she wasn't making that up. When you think about what she did the same thing Dan did. Rachel Ramey reported to the Michigan Intelligence Operations Center about the Wolverine Watchman, about Joe Morrison, and about the dangerousness of it. And she did the same thing Dan did. When he saw what he saw in his phone, he called police officer Ramirez. And, you know, her testimony, and, you know, you go back to, okay, Ramirez lied. Okay, now Ramey's being accused of lying. Now, anybody who testifies against the three defendants is going to get accused of lying. And when you look at this, you know, the wheel of conspiracy, these 9 people are independent of each other. And one of the instructions that Judge Wilson is going to give to you is that when the evidence and the testimony agrees with the witness's testimony, that witness's credibility is improved. And to suggest that these 9 people somehow conspired against the defendants and victimized them is not supported by the evidence in the case. A little bit about, the idea that they trained because they were seeing the riots. And it's not case. We lawyers don't have the ability to deliver evidence to you. And the only people that have said the defendants did what they did because of social unrest are the lawyers who represent them. No witnesses took the witness stand and said that. No evidence in chats, audio, or anything else exists that suggests that Pete Musico, Joe Morrison, and Paul Bellard were on some crusade for, to save the world. No, they were interested in themselves. And so anybody who gets on the witness stand and testifies against them is going to get, accused of lying. And, when you look at these are posts from the night they went down to Detroit. Remember, Mr. Bellard lives out in Oakland County, Milford, and Mr. Musico and Mr. Morrison live here in Jackson County, okay, out on Dunn Road in Munich. And they all trooped, Mr. Bellard for the Detroit QRF, trooped down to Detroit, and we'll talk more about that when I get into his closing here in a moment. But, this is, the mindset of Joe Morrison and what's going on with, and also Mr. Musico, about what's going on the night that the QRF, and remember, this was one of Joe Morrison's early things he wanted to achieve, was the ability to deploy QRFs, okay? And here it was in action. And, you see I'm so happy right now. That's a fucking pig roast, boys. This shit makes my pee-pee hard, is what Joe Morrison had to say. They're going to drag these cops in Detroit. I mean, does this sound like people who are interested in social change to you? Does this sound like people who are going to go to a protest with a sign and march and send a letter and try to, create change through a peaceful, non-violent means? No. And then what does Pete Musico have to say? Now is the time to strike. The iron is hot. And again, this is after the Black Lives Matter march down in Detroit. It started on the 29th and went into the early morning hours of the 30th of May. They wanted civil unrest, and the reason they did, they sought it out, like going down to Detroit, none of them lived close to it, was because they wanted to boogaloo. I mean, the boogaloo is not some mythical thing. It is you can see from the course of the evidence in this case, I mean, it is a phenomenon that's understood and by individuals who are part of that. They have markers to, tell other people that they're part of it. They hate our government, okay? So, the suggestions made that the defendants are in some way, social justice warriors. They're going to go out there and right the wrongs of this tyrannical government that we appear to be living in when you look at it through their eyes. And you see here, Joe Morrison's post is trying to weed out the status and try to get Mujahideen and not so much these people who thinks it's a militia and about changing laws. No, they were into the booth. I mean, and here's the thing. There's, this idea that's been put forward by Mr. Ballard on behalf of his client, Musico on behalf of Mr. Johnson on behalf of his client, and to a certain extent by Mr. Patrick, that the troubling times that they were living in caused this. And these were people who were concerned about social justice issues, and it's okay to stomp your feet and object to your government. These guys weren't interested. The only thing that you got during the course of this trial that supports that premise are the words of the lawyers representing the defendants. There was no evidence submitted during the course of the trial, either from testimony or from exhibits or anything else, that suggested to you that these defendants were actually more socially, their social causes is what motivated them. They wanted to right the wrongs of our society as they saw. No, these guys were interested in themselves. Okay, they were interested in the booty. I mean, again, get back to motive. People don't do things by accident. Even a simple trip to the store is motivated by something. And the idea that these guys were looking out for other people, it's vacant. I mean, the only people who have suggested that are the defendant's lawyers. Okay? And that's not evidence. And remember what Joe Morrison said in that one posting of his. He's looking for well-disciplined gunfighters. One of the things that was talked about during Mr. Musico's closing statement by Mr. Johnson is the training is just shooting guns. Well, that's partly correct, but it doesn't obviously reflect all the evidence. And the training was for the boot. I mean, and L-shaped ambushes, vehicle takeovers, insurgency tactics, movement under fire, tactical reloads, convoy tactics, center breaching doors. I mean, and I could go on and on. I mean, room clearing. I mean, no, they weren't defending anybody. I mean, they wanted the booed, and they weren't interested in anybody but themselves. They wanted it to happen. Let's turn now to Mr. Morrison and talk about him a little bit. The statement by Mr. Ballard on behalf of his client was that, Joe Morrison was just a larper. And, keep in mind that even if he's not going to commit the act of terrorism, if someone else is going to, then he's more than willing to help him. Okay, Joe Morrison. And that's what he's charged with. And this is what he has to, and this is what we offer. And, I guess, in contradiction to Mr. Ballard's assertion on behalf of his client, that Mr. Morrison is just a larper. I don't want this to become a group that just plays army man. Let's think about that for a minute. As kids, we grew up and some of us played army, and and what Joe Morrison's saying there is, no, those are his words. Okay, there's no. I mean, I want a real deal outfit with their buddies in the woods with their buddies, and lets tyranny run rampant. Now, I mean, there is his connection to the Boogaloo. The Boogaloo movement believes that all government is tyrannical, and he's showing some of his ideology there. And I agree, we need to get organized and trained, absolutely. And the next phrase is very important. But I want us, the group, not one person, a gang, to be able to act when the time comes to act. And when was that time? Well, they were the deciders. Remember, I mean, they're the ones that were going to police the police. And they were the ones that were going to decide when to act and where at a moment of their choosing. There was a lot made about the transcripts and the cross-examination of the witnesses. And I'm going to talk a little bit more in a moment here. The allegations made by both Mr. Ballard and Mr. Patrick on behalf of their clients that they feel that they were given short shrift or in some way have been victimized by the process that they're going through here. And when you think about cross-examination of the witnesses and the rigor of it, okay? Remember, Dan has testified 5 different times. Okay, hundreds and hundreds of pages of transcript. And you guys saw the cross-examination, how it works. It works like this. Hey, what color was that car, pulled away from the bank? It was red. Okay, well, are you sure it was red? Yeah, it was. Well, yeah, you sure it wasn't maroon? Well, I mean, it could have been a deeper red color, if it was candy apple red. I mean, it's the rigor of cross-examination is number one. I'm not trying to degrade it. I mean, it's part of the process that we entertain when we do a trial. They're allowed that cross-examination. What I'm trying to point out to you now is the cross-examination that occurs is witnesses get asked the same question multiple times, especially in the cross-exam. And what's hoped for is that the witness will use different words in different answers, in the same answer. As they move through the process, they're testifying in preliminary examination. They use certain words to describe an event. Now they're in an evidentiary hearing. They use different words to describe the same event. Now they're at trial. They describe the same event using slightly different words. And then that's picked apart through good lawyering. Oh, you didn't say that exactly the same way here. That's not the way life works. Okay. And the way the people recount events, they don't use the exact same words every time. So to suggest that the witnesses aren't believable, and it kind of gets back to that wheel of conspiracy, if you will, that this is why you can't believe Dan or anyone else who took the witness stand, doesn't hold water when you think about it in a real life setting. And I also invite you to think about the instruction the judge is going to give you, that I mentioned earlier, is that if a witness's testimony agrees with other evidence in the case, then that testimony is more credible than if it disagrees with other evidence in the case. Mr. Ballard, on behalf of Mr. Morrison, suggested that the reason the defendants did what they did was because of unprecedented times. He pointed to the pandemic as the first thing that he uses to try to use Mr. Morrison's conduct. And the pandemic, if you think about when Morrison kicked off the Wolverine Watchman, he did that in November of 2019. And we talked about how Joe Morrison's motive was that arrest over in Macomb County. He started the Wolverine Watchman. It started one day after the day he got done with the sentence. I'm sorry, 5 days. So he was mad about that. And, we've heard different people tell you about it. Dan talked about it. Mark talked about it. The testimony was quite clear amongst multiple witnesses that Joe Morrison did not take kindly to that arrest. In fact, Trooper Trusser came in and testified, and I said, he was still mad when several months later he called my boss and I started trying to challenge the arrest. And no, that arrest over in Macomb County, at one point we're going to say Mr. Bell trying to suggest that it was bad. 23. No, he was at a traffic stop out of I-94 in Macomb County. It wasn't some bad news. That's an example of why lawyers' statements aren't evidence. Okay, and Trooper Trusser's statements are evidence. And his testimony was quite clear that Joe Morrison committed a CCW offense there, and he got arrested and charged with it, and he did not like that. He did not like that event. Nobody. Just think about it. That would not be a pleasant thing. And if you're a guy who hates the government, now you're getting fired up. Okay. 5 days later, he starts the war. Watch. So And, you know, what this is, that's being offered by Mr. Ballard on behalf of his client is, you know, these are opportunistic defenses. By opportunistic, I mean, these are defenses that don't really, they're not real. I mean, these are events that are coinciding with the time that the events happened in this case. But if you think about the defendants and what their chats were all about, the communications and all the recordings, these guys, they were not the least bit worried about George Floyd. I mean, they did not talk at all about, you know, how unjust, you know, his death was. They were not, you know, concerned with, you know, the different people who have died, you know, in the hands of police and you know, in questionable circumstances. No, they were only interested in themselves, and what they liked was the boot, and that was their flavor. And, you know, tell you what the pandemic did, though, is it gave them traction to recruit. I mean, they were not concerned with it. And, you know, just what it did was it gave them another reason to hate our government. Mr. Ballard, on behalf of Mr. Morrison, yesterday told you that Dan fell down in Iraq, and that's how he got hurt. That's what he said. You know, on behalf of his client, he's trying to sell you is that Dan fell down in Iraq, and that's how he got hurt. And because he doesn't have a Purple Heart, that means that he wasn't injured during the course of when his duties were in Iraq on behalf of our country. And here's the most poignant part of his testimony I asked him to think about it on this issue. And it's when Judge Wilson asked him, hey, Dan, can you tell me a little bit about your experience up in Sadr City in Iraq? And Dan laid it out. And Dan told you, you know, about his 68 days up there and what they did and what the mission was. And Dan told you about how he got injured when he was in Humvee, and there was 2 IEDs that went off. They got out. Nobody, you know, needed to go to the hospital immediately. The vehicle is still running. You know, makes sense. Let's get back in and keep moving, because if we don't, someone's going to start shooting us. And it was after his discharge, and this is his testimony, in 2010, he comes back here to Michigan, goes to the VA, and gets diagnosed that 2 things are going on: TBI, traumatic brain injury, and also the orthopedic injury to his leg. The VA schedules him up for orthopedic surgery, and this was his testimony. This is not me. I mean, this is what he testified to you know, in the second week of trial. And in between the time that his surgery was scheduled and the time, you know, he was on ATV and he injured it further. And that the injury that he sustained on the ATV was because his leg had been weakened from the event in Iraq. Okay, that's the testimony that Dan provided you on Judge Wilson's question. So to suggest that Dan in some way fell down in Iraq is very disingenuous. Mr. Ballard, on behalf of Mr. Morrison, says, I'm a victim. The Constitution has been shredded. Well, let's think about that for a minute and what constitutional protections have been afforded Mr. Morrison and all the defendants. During the investigation, when the special agents wanted Facebook records or those kind of communications, they had to go to a judge and ask the judge for permission, search warrant. The judge signs the search warrant, and then they send the search warrant off to Facebook, and Facebook returns the records. That's how that process works. Okay, my point is there's a judge involved in the process, and it's not, you know, just the agents going out and going to the Facebook office and saying, give me everything you got. They had to explain to a judge why that search was reasonable. At the end of the investigation, the defendants are arrested. They don't just go out and arrest them. I mean, before they do so, they seek a judge's permission. These are all benefits that inure to Mr. Morrison. Because remember, Mr. Ballard said, poor Mr. Morrison, constitutional rights were shredded. They went out, the judge said, yeah, I believe there's probable cause here to arrest these defendants. You're authorized to go arrest them. Day after that, now we're in a court process. Okay, the first thing that happens in the court process is prosecution and the investigators rather are ordered to turn over everything in discovery. This is, so everything that we have is what they have, okay? There's no hidden rock here, okay? We're under court order to do that, and we take that order very seriously. Judge Wilson said, you know, no one's going to bet their career on hiding a piece of paper. Okay, when their examination, the right to confront witnesses. You know, this is where they're afforded the opportunity to say, hey, there's not enough evidence to go to trial, Judge. In this case, that preliminary examination was held, and they made their arguments, and now the case is here in trial because there wasn't enough evidence supplied. There was an entrapment hearing back in February, an evidentiary hearing before Judge Wilson. You're going to get an instruction on this. Because during the course of this trial, at different times, each attorney for each defendant has tried to argue a form of entrapment. And it basically goes like this. Dan led them into it. Dan is the one that created this crime, okay? That argument is a legal argument. That is, the judge decides whether entrapment, you know, was shown. Judge Wilson's ruling in February was, no, there was no entrapment. He's going to instruct you that you should not consider entrapment as a defense, okay? And Dan had to testify at that hearing too. And he was accused of lying there as well. And then finally, and this kind of goes back to my start when we opened this morning, the jury trial. You know, you have now, as a body, and you've witnessed, you know, what a jury trial in America looks like. And this is it. And this is how we do it. You know, it's one witness at a time, one question at a time. And to suggest that in some way, Mr. Morrison is a victim here because his attorney thinks the Constitution has been shredded is not supported by the evidence. Now, what Mr. Ballard said about Mr. Ramirez, and we've talked about him, you know, Mr. Ramirez can't be believed because he didn't take a picture of what he saw on that phone, so you should disregard his sworn testimony. Remember, the judge is going to instruct you that sworn testimony is evidence. It's evidence just like a picture. You know, when you think about most things in life, I mean, most people, most events don't have the benefit of a recording, okay? In this case, there's a lot of it. And it hopefully is a benefit to you when you make your decision, in making your decision. So you know, the question that is kind of left at the end of it is, you know, when would Mr. Ballard be satisfied? Mr. Ballard tried to suggest to you that protests were just for protesting, and that, you know, Joe Morrison was some type of social justice warrior. And this is his message to the group in April, you know, when the pandemic was just getting started, and, you know, we were all in our homes wondering what was going to happen. And we're in the recruiting business, and boys, BOIS, business is booming. The pandemic was good for the Wolverine Watchman. It was good for Joe Morrison. You know, and Joe Morrison took this really seriously. You know, suggested by Mr. Morrison that this was some side thing for him, and by Mr. Ballard. Mr. Morrison didn't really take this risk. You know, it was just something he was doing. It wasn't that big of a deal to him. And I'd suggest that, you know, the wire chat from yesterday that we admitted, you know, where he's talking about, listen, I had to take a week off from, you know, the Wolverine Watchman in 10 days, you know, to work on my marriage. And, you know, I worked essentially, you know, I worked my butt off trying to get this thing to where it's at. And there's no communication where he says, you know, this is far more than I ever expected, you know, this group to develop into. And his use of the word boys there, you know, instead of BOIS, BOIS, you know, is again his attribution to the Boogaloo movement. I mean, this was important to them. as crazy as the Boogaloo movement may sound to people that, like yourselves, no, it's a real thing to people. And it was a real thing to Joe Morrison. Let's talk about Mr. Bellard here. One of the first things that happens during a trial is we have opening statements. And Mr. Kirkpatrick, during his opening statement, told you that Fox and Croft were terrorists. He admitted that, and rightfully so, because when you get done going through this trial, you see how both Adam Fox and Barry Croft were terrorists. And Mr. Ballard shared the same sentiment during his opening statement on behalf of Mr. Morrison. And that is that he said the same thing. He admitted that Fox and Croft were terrorists, okay? I mean, this is a known commodity. They are, Fox and Croft are known commodities. And when we think about Mr. Bellard, Bellard spent the most face time with Adam Fox amongst these three defendants. And, the back shack meeting in and of itself was a 3-hour event in the basement of the back shack. And, that was more than sufficient. The evidence supports that was more than sufficient to educate Paul Bellard as to what Fox is all about. Again, his brand was about political violence. His brand was about, bringing the fight to people that he thought were oppressing him. We entered several videos of Mr. Fox that he posted, and it's not hard to understand his brand. And, one of the things that I ask you to keep in mind is, you've heard a lot of evidence about Mr. Bellard's brand. And Mr. Bellard's brand, for instance, when he says, when he's out in Detroit QRF, well, if they go lethal, I'm going lethal. And, I hope the cops put their back plates in today. And we'd be the wrong car to mess with. Their brands are identical, okay? And, this is where I ask you to use your common sense. You think about two guys sitting down together. I know there's more than two people there, but two guys sitting down together, Adam Fox and Paul Bellard. And do you think either one of them had a real reason to pull back and be restrained during that meeting in the back shack? Absolutely. And that's where Adam Fox is talking about, hey, if you storm the Capitol with 300 guys, have another 700 come in from, a follow on. And that's how we could oppose, anybody trying to take the Capitol back. Crazy idea. Doesn't matter. I mean, remember what they're charged with. Providing material support for Adam Fox in his plan to commit a terrorist act. It doesn't have to be a good plan or a great plan. As a footnote to that, remember the migration of Adam Fox's plan. I mean, Adam Fox's plan, Adam Fox benefits from his association with the Wolverine Washington, because his plan goes from, that plan of I'm going to take the Capitol to, no, I'm going to do something more doable, something that can be done by fewer men and something that's probably less guarded. I'm going to go to the governor's house at 3 a.m. That's Pete Musical's plan. And Adam Fox migrates to that 3 plan that Pete put out in the beginning. Okay, so that's what they're charged with. And at that back shack meeting, Paul Bellard gets the full dose of Adam Fox. Okay, so it was suggested by Mr. Kirkpatrick on behalf of his client that Paul Bellard was in some way repulsed, put off, or didn't want anything to do with Adam Fox. And yet, even if Dan does drive him, and this is why evidence doesn't come from lawyers. in Mr. Patrick's opening statement told you that, Paul Bellar, everything was paid for by Dan to go to Wisconsin. And when Mr. Bellar was at the table at dinner that night on Saturday with Barry Croft, and Barry Croft was holding court, doing what Barry Croft does best, that, Paul Bellar was, he used the words, drunk as a skunk. That's the statement by the defendant's attorney on behalf of the defendant. Now, what was the evidence in the case? The evidence in the case was Dan said, I drove him, he charged gas, no, I didn't pay for his room, bought him one meal, and while we were at dinner that night with Barry Croft, he had one bill. So, I ask you to take the evidence from the witness stand and the exhibits and also circumstantial evidence that makes sense to you. It's not what the lawyers say. Mr. Kirkpatrick tries to distance the importance of the QRFs that Mr. Bellar deployed during the month of May of 2020. And, these QRFs, show Bellar's alignment with the Boogaloo ideology, okay? I mean, it shows that, and it's the same ideology that's mirrored by Adam Fox. And it's no coincidence that these two landed together. And the QRFs did several things. First of all, it shows you what Paul Bellar's intent is when he's training Adam Fox. Even if Paul Bellar doesn't want to go and do a operation against the governor, he's not charged with that. He's more than willing to help Adam Fox. And these QRFs show that because they're the same brand. It's the same, it's two individuals, they share the same brand is political violence. And they also show his alignment with, again, the Boog ideology, and that's mirrored by Mr. Fox. And, keep in mind what the testimony of Dan was. And Dan spent a lot of time with all the defendants. It is that he said by far, Paul Bellar was the most aggressive of the three defendants. And, when you look at the QRF's deployment, you think about, what am I doing on a May afternoon, on a Sunday afternoon? I'm going to get all kitted up. I'm going to get a few of my guys. I'm going to go up to Fenton. I live in Milford. And I'm going to protect one of my Boog boys because, I think, the person he's selling the gun part to might be affected. And then I'm asking you to think about Dan's testimony when he says Paul Bellar is the most aggressive, and whether that's believable. And then think about what Paul Bellar said after that event. He said, I don't know if it's good or bad, but I was kind of hoping that guy wasn't bad. Paul Bellar and Adam Fox shared the same brain. This is from the Back Shack meeting, and this is Garvin and Bellar bragging to Fox about how good the Wolverine Watchmen are.
And then that was top notch. Us three, and the other guy, speaker that you met, he was a teacher, and one other guy, we were down in Detroit, full kick with the truck 2 blocks out. We had a couple guys on scanners. I was fucking sitting there in the truck monitoring the airspace on my tablet.
We still remember how in the actual crowd was kind of like looking back at
2 guys.
drivers.
Yeah, well, they were. I like how you do it. Oh, man. So we had 4 guys on the ground in the protest relaying information back to us. We had a guy on the scanner. I was monitoring the airspace. We were full kick down my truck. That's how you. That was that was great.
Bellar was dangerous. He didn't have any problem with Fox's plan. This is Fox's review of the training with the Wolverine Watchman. And, he says, you guys have your shit together far more than anyone we've trained on. It was suggested by Mr. Kirkpatrick, and this was one of his main thrusts of his closing on behalf of his client, Paul Bellar. It is one training wasn't enough. Essentially what he argued. He was like, that one training on June 28th wasn't enough. And that's like arguing, he only robbed the bank once. Well, that's not the way the law works. And he committed the crime on June 28th when he trained Adam Fox out on Dunn Road. When you think about it, all these defendants brought Leroy Jenkins, Adam Fox, to Jackson County for training. And Paul Bellar helped do that and provided training to him there out on Dunn Road. And what Mr. Kirkpatrick's attempt is, and again, attempt to raise the burden of proof. One's not enough, he said. One isn't enough. You know what? You won't hear any instructions from Judge Wilson. Another, what he's trying to do also is add an element to the crime charge, because you saw the elements to the crime charge, and there's no requirement that it be, 2, 3, 4 times. It's, did he provide training to Adam Fox? That is the question that's before you. And, keep in mind, as Mr. Kirkpatrick said in his opening statement, Adam Fox and Barry Croft were terrorists. Well, it seems like then that Adam Fox ought to know what good training looks like, what good terrorist training looks like. As I commented before, Adam Fox's plans evolved. And when you look at what on the 18th of June, his back shack plan is, let's take the Capitol and televise it and hogtie the governor. 2 days later, well, let's storm the Capitol. We'll get 700 guys to back us up, and put snipers on the roof. And Pete said that that's he made the suggestion that Pete Musico did at this point. Well, wait a minute, let's just go to their houses, and talking about that being like a patriot-like act. And then on the 28th at the training, recruiting people to storm the Capitol and taking hostages and using explosives to do it. That's his plan as it's migrating forward. And, the judge is going to instruct you on what a terroristic act is. And all 3 of those acts, or any version thereof, or visiting the governor's address, to kidnap her, are terroristic acts. Okay, Mr. Bellar's intent stays the same after he commits the act. And in the act being on the 28th of June, he commits the act when he trains Adam Fox out on Dunn Road at Joe and Pete's property. And he forms up his group on the 7th of July. And, it was suggested to you by his attorney that the reason he does that is because in some way he's not down with Adam Fox's plan. No, the reason that he leaves the Wolverine Watchman is silly in a way, but understandable. He brings his girlfriend to training on the 28th. And as you can tell from the clips in this case, Jada, that's Joe Morrison's wife, is not a wilting flower, and she has an opinion, and she let it be known on that date, no women at training. This is my house. And okay, Paul Bellar didn't like that. And remember what he tells his girlfriends too. I'm going to be known as a domestic terrorist. Over Paul Bellar. Okay? He brings one of his girlfriends to training. That's what separates him from the okay? And you read his explanation as to why he's leaving. And he has no problem with the Wolverine Watchman, just different preferences, he says. So this is the consistency of his intent all the way through. And, you know, the Wolverine Watchman forms up his ghost group on the 7th of July. He reaches out to Adam Fox the same day and, hey, sir, it's Doc. I mean, does that sound like, you know, somebody that you're communicating with that you don't know, or that you want a distant relationship with? No, it's quite respectful, actually. He's demonstrating respect to Adam Fox at that point. And what, you know, remember, Adam Fox is the VIP that's coming to training. Adam Fox comes to Wolverine Watchman through Barry Croft. Barry Croft is a national figure in the Boogaloo movement, okay? And Paul Bellar knows that. So Paul Bellar is looking at Adam Fox as a type of VIP national contact. He wants to keep his options open. That's what he's doing here, and this is showing his intent. He did not abandon his ideology when moved. Another thing that shows that is the warning that he issues that police have been at his house and that the code words have probably been found. And he's reaching out to the Wolverine Watchman at this point and saying, hey guys, change the code word, do it now. And if he's out, then why is he warning the Wolverine Watchman about the police being at his house? You know, Paul Bellar is loyal to the Wolverine Watchman movement. This is another example of it. When he reaches out on the 18th of June, remember how much Mr. Kirkpatrick pounded on the podium. You know, that, you know, his guy was gone. He didn't do anything. He left. Well, you know, why is he reaching out a month later and warning them about Dan? And this is why I say, you know, it's Dan is lucky to be alive. You know, has his ideology changed? Well, this is from the 22nd. Again, you know, he's reaching out to, you know, the guys on Facebook and the Wolverine Watchman, and he's like, I started a group down here called the Palmetto State Goons. Hopefully I don't end up on another list. You know, his experience in Michigan is teaching him. He's becoming a more formidable person, a more dangerous individual as the days go on. And another list with this one. I'm really sorry. Now, I mean, why is he apologizing to people he doesn't care about? Well, because he does still care about them. Why? I mean, I'm really sorry for what happened recently, just hoping it didn't piss any of you guys off. You know, the Wolverine Watchman still mattered. You know, he still cares for his fellow gang members, is the short version of it. And some things don't change. This is, you know, another example of the wheel of conspiracy. You know, when Mark testified, you know, you see Mark testified that, yeah, Mr. Bellar, you know, went up to, I was at Cambria, and that, you know, Fox went through the medical training that he was doing. And the only conclusion that Mr. Kirkpatrick made on behalf of his client was, well, Mark's lying too. Well, again, you know, you think about all these witnesses that testified, anybody who points the finger at one of the defendants gets on the wheel of the conspiracy, okay? You know, I ask you to think about this a little bit. And there's a gang charge here to really talk about, and that is, you know, how do these defendants know each other? You know, Pete and Joe know each other because, you know, Joe's married to Pete's daughter, too. But, like, you know, how do the other Wolverine Watchmen know each other? Think about the testimony that you have. You know, Mr. Ballard, on behalf of Mr. Morrison, you know, it was talking really on over the years. Oh, well, motorcycle club must be my motorcycle club must be a gang. The you know, my church must be a gang. My poker group must be a gang. No, you know, and you think about like the people that you do those kind of activities with. I mean, there are, you know, you might have friends from school, you know, when you were younger. You might have friends from, you know, your church. You might have friends from, you know, maybe a social club you belong to, and or your neighbors. I mean, and you look at like what brings people together, okay? And the only thing that bound these people together was their ideology for political violence and their belief in voodoo. I mean, it's not like Paul Bellar knew Joe Morrison growing up. It's not like Paul Bellar and Pete Musico used to live next to each other. It's not like Mr. Bellar and the other Wolverine Watchmen shared anything in common except for their belief in the Boogaloo and their membership in the Wolverine Watchmen. And you know what connected those people is what I would suggest to you: circumstantial evidence, and it's very believable because their relationship was hinged on one point, and that was, you know, political violence. The gang is what brought them all together is my point. So concluding here, wrapping things up, I'm going to leave you with this. This is Mr. Bellar, and this is what he's talking about up in Cambria. This is after he has trained Dan at the Munich property. I'll play this for you, and I'd ask that you listen carefully because this is Mr. Bellar's confessions.
I feel like when you go do this, I feel like we need to like kind of step up as a team and maybe show them the proper way. I see, because Adam already knows this, we've been teaching it to him. Right. I feel like when you go do this, I feel like we need to like kind of step up as a team and maybe show them the proper way. I see, because Adam already knows this, we've been teaching it to him. Right.
His own words. Adam already knows it. We've been teaching it to him. Okay. July 12th, 14 days or so after he's trained Adam at Munich. I told you early on that this was a simple case. We tried to summarize it as best we can and try to make it understandable and simple. We have proven this case beyond reasonable doubt. I'm going to ask that you disregard the attempts to add elements or increase the burden of proof. I'm going to leave you with this thought. You can put Paul Bellar, Joe Morrison, or Pete Musico where they are today. They made their own choices. They're grown-ups, and no one forced them to do anything. Their conduct spanned months. This wasn't a one-time event where they made one singular bad choice. They're not victims. We have shown that they provided material support to Adam Fox for a terrorist attack. We have shown that they are members of the Wolverine Watchmen, a gang, and that gang provided them a means and motive to commit the first offense. And that when they did the first offense, they also had guns. We thank you very much for your time and your sacrifice, and I mean that from the bottom of my heart. It's not like this is easy to do, but we're going to ask that you return a guilty verdict against the three defendants on the three charges in the case. Thank you very much. Thank you, Judge.
Thank you. We'll take a break. I'll come back, give you instructions, and then you'll go to lunch and you'll have all afternoon to talk. We'll see you tomorrow. Okay. Members of the jury, the evidence and arguments in this case are finished. I will now instruct you on the law. That is, I'll explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors. You may have different backgrounds and perspectives, who may have backgrounds and perspectives different than yours. As jurors, you must decide what the facts of the case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, apply it to the law as I give it to you, and that way decide the case. Before going farther, I want to let you know I'll be sending a whole packet of these back with you. So if you have any questions, you'll be able to look through the jury instructions. A person accused of a crime is presumed to be innocent. This means you must start with the presumption the defendants are innocent. This presumption continues throughout the trial and entitles the defendants to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that they are guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has an absolute right not to testify. When you decide the case, you must not consider the fact the defendant did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that's been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll describe some things that are not evidence. The fact that defendants are charged with a crime and are on trial is not evidence. Likewise, the fact that they've been charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept the things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to witnesses, my questions to witnesses, are also not evidence. You should consider these questions only as they give meaning to the witness's answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see the trials conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. Times during the trial, the excluded evidence was often offered or stricken testimony was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in, nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. but you should not use any personal knowledge you may have based on a place, person, or event. But once more, you must decide this case based on only the evidence admitted during the trial. Now, as I said before, it is your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or social economic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. Now, there is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to make an honest effort to tell the truth, or did the witness seem to evade the questions or argue with lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in this case? Now, sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in this case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything the witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Now, during the trial in this case, the defendant has advanced a theory of entrapment by the government and its agents. Put another way, the defense has attempted to elicit evidence that the government and its agents engaged in activities that impermissibly manufactured or instigated the crimes in this case. However, entrapment is a legal theory that is a matter of law for the court to decide. In other words, it is for the judge, not the jury, to decide whether entrapment is present in this case. Prior to this trial, the court took testimony on this theory and subsequently ruled that there was no entrapment by the government and its agents. As such, whether the defendants were entrapped by the government and its agents is not a question for you to decide. And so instructing you, the court is not trying to keep anything relevant from you. This is because entrapment is not an issue relevant to whether the defendants are guilty of the charged crimes, determination which you as the jury and you alone must decide. Moreover, by having previously ruled that the defendants were not entrapped as a matter of law, the court is not commenting on the truthfulness or veracity of a given witness, the quantity or quality of the evidence against each defendant, or whether each defendant is guilty of the charged crimes beyond a reasonable doubt. Again, those determinations are for you and you alone to make. Pete Musico, Joe Morrison, Paul Bavar are all on trial in this case. The fact that they are on trial together is not evidence that they were associated with each other or that any of them is guilty. You should consider each defendant separately. Each is entitled to have his case decided on the evidence and the law that applies to him. any evidence was limited to one defendant or some defendants, you should not consider it as to any other defendants. Now, the prosecution must also prove beyond a reasonable doubt that the crime occurred on or about November 1st, 2019 to October 7th, 2020 within Jackson County. Defendants are each charged with 3 counts. That is the crimes of providing material support for an act of terrorism, gang membership felonies, and weapons felony firearm. These are separate crimes, and the prosecutor is charging that each defendant committed all of them. You must consider each crime separately in light of all the evidence. You must return a separate verdict for each defendant. For each defendant, you may return a verdict of guilty of one or more of the alleged crimes or not guilty. Remember that you must consider each defendant separately. The facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. When lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether a defendant had reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. Prosecution does not have to prove that the defendant had a reason to commit the alleged crime. Prosecution only has to show that the defendant actually committed the crime. Defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. Testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Prosecution has introduced evidence of statements that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give that statement whatever weight you think it deserves. In deciding this case, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of this case. Possible penalty should not influence your decision. If you find the defendants guilty, it is the duty of the judge to fix the penalty within the limits provided by law. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. Defendants Paul Bellar, Joe Morrison, Pete Musico are charged in count 2 with providing material support for a terrorist act. To prove this charge, prosecution must prove each of the following elements beyond a reasonable doubt. First, defendant provided material support or resources to Adam Fox or Barry Croft. Material support or resources means any one of the following: or other financial security, financial services, lodging, training, safe houses, false documents or identification, communications equipment, facilities, weapons, lethal substances, explosives, personnel, transportation, including any related physical assets or intangible property, or expert services or expert assistance. Second, that when the defendant provided material support to Adam Fox or Barry Croft, he knew that Adam Fox or Barry Croft would use the support or those resources, at least in part, to plan, prepare, carry out, facilitate, or avoid apprehension for committing an act of terrorism against the United States or its citizens, Michigan or its citizens, a political subdivision or agency of Michigan, or a local unit of government. An act of terrorism is committed or attempted to be committed or attempting to commit the violent felony of murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, or kidnapping that was or would be dangerous to human life and was intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion. Murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, and kidnapping are violent felonies. You must decide whether the crime was or would have been dangerous to human life and whether the defendant intended to intimidate or coerce a civilian population or intended to influence or affect the conduct of government or a unit of government through intimidation or coercion by felony. Elements of the charge: gang membership, felony. Defendants Paul Bellard, Joseph Morrison, Pete Musico are charged in count 1 with gang membership, felonies. To prove this charge, the prosecution must prove each of the following elements beyond a reasonable doubt. First, that there was a group of persons that was a gang. To prove the group of persons was a gang, the prosecution must prove that it was a group of 5 or more persons who had continuing relationships with each other and identified themselves in all 3 of the following ways. The group had a unifying mark, manner, protocol, or method of expressing membership, which may include a common name, sign, or symbol, means of recognition, geographical or territorial sites, or a boundary or location. The group had an established leadership or command structure. The group had defined membership criteria. Second, the defendant was a member or an associate of the gang. Third, the defendant committed or attempted to commit the felony crime of providing material support for an act of terrorism, as has previously been described to you. Fourth, the defendant's membership or association with the gang provided the defendant with motive, means, or opportunity to commit the crime of providing material support for an act of terrorism. Elements of the charge: weapons, felony, firearm. Defendants are charged with count 3 with weapons, felony, firearm. To prove this charge, prosecution must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed the crime of providing material support for an act of terrorism, which has been defined for you. It is not necessary, however, the defendant be convicted of that crime. Second, that at the time the defendant committed the crime, he knowingly carried or possessed a firearm. Now, when you go to the jury room, you will be provided with written copies of the final jury instructions. You should first choose a 4-person. The 4-person should see to it that your discussions are carried on a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other, make every reasonable effort to reach agreement, express your opinions and the reasons for them. But keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try and reach agreement, none of you should give up your honest opinion about the case just because the other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise after the deliberations, you may submit them in writing in a sealed envelope to the bailiff. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It's not proper for you to talk directly with the judges, lawyers, or court officers or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return a unanimous verdict, do not reveal this to anyone outside the jury. I already noted, when you go to the jury room, you'll be given a written copy of the instructions you've just heard. As you discuss the case, you should think about all the instructions together as the law you were to follow. And then we have verdict forms. Defendant Paul Bellar, possible verdicts. You may return only one verdict for each count. Mark only one verdict for each count. Count 1, gang membership felonies, not guilty. Guilty of gang membership felonies. Count 2, providing material support for a terrorist act, not guilty. Guilty of providing material support for a terrorist act. Count 3, firearm, not guilty, or guilty of a felony firearm. Joe Morrison, possible verdicts. You may return only one verdict for each count. Mark only one verdict for each count. Count 1, gang membership felonies, not guilty. Guilty of gang membership felonies. Count 2, providing material support for an act of terrorism, not guilty, or guilty of providing material support for an act of terrorism. Count 3, felony firearm, not guilty, or guilty of felony firearm. And a verdict form for Pete. You may return only one verdict for each count. Mark only one verdict for each count. Count gang membership felonies, not guilty, or guilty of gang membership felonies. Count 2, providing material support for an act of terrorism, not guilty, or guilty of providing material support for an act of terrorism. Count 3, felony firearm, not guilty, or guilty of felony firearm. Got all your names. Smoke containers. Shake those up. Before you do it. Whoever the two of you are that get drawn off right now, I've got to ask that you don't discuss this. Had it happened before where we've had an extra juror or two. Something happens, you get a car accident, somebody's sitting on the panel, something happens, and they're just not going to be back for a long time. And then we've got to call, we'll put whoever the two are, we'll put the names in the thing, we'll shake them up, we'll draw one out, that person will come back. You've got to start your deliberations over at that time. So it's important that whoever the two of you may be, that you don't discuss the case, because when you start talking to people about what you've been through here, they're going to give you their opinions, and you may be influenced by what other people are telling you. They didn't sit here, they didn't listen closely to everything that went on. So I've got to strongly ask you to not discuss it. As soon as we do have a verdict, we will contact you. We will let you know what the verdicts are. Okay. Corey, go ahead and reach in there and draw out a couple.
Juror number 8. Juror number 6.
Okay, thank you. I know it seems sort of frustrating to sat and listen to everything. But like I said, if anything happens, we'll be calling you back, and you still could get called, so please don't discuss it with anyone. We're gonna send you all back to the jury room at this point. Well, we're right at lunch. Why don't
I need
we?
to swear Corey in.
Huh?
I need to swear Corey in.
Oh, yeah, because you're gonna be covering the bailiffs. Go ahead and swear him in, then we'll let him go.
Do you solemnly swear that you will, to the utmost of your ability, keep the jurors from separating from each other, that you will not allow any communication to be made to them, that you will not communicate with them except under order of this court, or to ask them if they have agreed upon their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
Yes.
And while you're back there, if you need anything, get a hold of Corey. We'll try and take care of it.
I turned my video off, Corey.
Thanks.
Prosecution.
We have Mr. Beller, no issues with the instructions, Your Honor.
No issues, Your Honor. Just the objection previously noted again.
Well, that's it on the entrapment, but that's been,
Right.
That's
been well
preserved for the
documented. You've all covered your tracks on that one. Okay, we'll break for lunch. I'm figuring be around 1 o'clock or so in case something quick happens.
Thank you, Judge.
Okay, have Corey.
sit out in my parking lot if you want. You can-
Judge, I sent over the, exhibit list of the final admitted exhibits to all council over the weekend, and we have a couple of
I've read
binders. Did you want me to give those to you or just wait until they're
Wait till they
requested?
ask, we'll come get them.
Sounds
Plus,
good.
also, I understand you had them on only the admitted exhibits on a stick.
That's right.
So we set up a computer if they want it back there for them.
Thank you, Judge. We'll have that whenever you want.
I'm just gonna pull the cart back in, because it goes in there.
Take care.
Yeah, we'll see.
I don't know what to have for lunch. Huh?
War Deer started at 10:03 at 9:46 a.m. It's beginning deliberations, 10:25 at 1.
Must trust him. It's just full.
Oh. Huh?
I've only been here about 3 years. That's all right.
I'm gonna turn the